Next case is case number 232115, West versus Stajcar. Here on behalf of the appellant Stajcar is attorney Bradley Grothe. Am I pronouncing it? Grothe? Okay, great, thank you. And here representing the Appellee West is attorney Bryan Goldsmith. All right, well, welcome. And Mr. Grothe, whenever you're, I'm not trying to rush you, so take your time getting settled in, but once you're settled in, you can begin your argument whenever you'd like.
Before I begin, I just want to let you know that I changed the batteries in my hearing aids today, but sometimes I've been known not to hear quite everything, and if I ask you to repronounce or say something again, just if you could speak up a little bit, I think I'll get my points across and be able to understand you. So thanks.
Thank you for letting us know.
Your Honors, may it please the court, counsel. The decision of the trial court in this matter should be reversed due to the recent decision of the Supreme Court in the Sundance Land Company versus Remark case. And in that case, the court basically found that if you have one party who owns property on both sides of a demarcation line, whether it be a fence, crop residue, whatever it is, that any potential claim of boundary by acquiescence before or during that common ownership is eradicated, and the clock starts running anew for a claim of boundary by acquiescence when you have a conveyance to another party on the other side of that demarcation line.
In the West brief, they brought up, I think presumably, and I'm going to ask him about this, but presumably recognizing the impact of Sundance on their case, pitched alternative claims of estoppel by acquiescence and practical location, which I think is kind of a subset of estoppel by acquiescence. And in your reply brief, you contend that they didn't preserve those issues for our review, okay? But as appellees who did not cross appeal, I don't think that error preservation applies. They don't have to preserve error. But we do have a doctrine that our case law has followed for a long time that basically says a successful party, like the West, can rely on an alternative ground to affirm provided the party urged the ground both in the district court and on appeal, even if the district court didn't rely on that ground in its ruling. I don't know if you're familiar with that line of cases, but I think their cases are pretty clear on that. So I'd like you to tell me why you believe the West can't rely on those alternative grounds for affirming. And I'd also like you to kind of respond to the merits of their claim on those theories in the event that we, disagreed with you.
Yes, Your Honor, and I reviewed those cases just this morning before I came. But I do believe that the appellees here have an obligation to present those arguments to the district court and have a ruling on those issues. Here, the appellees have none of those. These arguments are made for the first time to the appellate court. I believe that the appellees saw the Remark decision and said, oh, there's another alternative argument here, but those arguments were made to the appellate court, this court, for the first time, and not to the underlying court.
But if we were to disagree with you and claim that they did adequately argue it to the district court such that they can rely on it as an alternative ground for affirmance, what are your thoughts on those two doctrines?
Well,
why don't they win on that ground instead of boundary line acquiescence?
Well, we also have the claim of estoppel by deed here. And Mr. West previously owned this property. And he previously conveyed the property that's now owned by Rodney Stajcar by a warranty deed.
And your alternative grounds, I want to talk about his alternative grounds.
Well, my alternative grounds, I believe, trump his alternative grounds.
Okay, but I want talk about his alternative grounds. Why do those grounds not apply?
It's a little difficult as an appellant arguing those before the appellate court for the first time when we don't have the ability to make a record of evidence that may contradict those particular theories.
You have evidence, don't you? Namely, when did Mr. West, Stajcar, thank you. I keep on wanting to call it Stajcar. Stajcar, when did Mr. Stajcar first come to the knowledge that the fence was in fact different than what the actual boundary line was?
I believe it was after he had purchased the property. You know,
What's the first element for estoppel by acquiescence?
I believe it's that the demarcation line would have had to be pointed out to him at the time of the conveyance.
Was in what year?
And the conveyance was in 2017.
And when was he sued?
He was sued in 2021. So, yes, I do not believe it was pointed out to him at the time of the conveyance. I don't really hear any arguments about estoppel by acquiescence. They use estoppel to bootstrap in practical location, but I would think the same arguments would apply. How can Mr. Stajcar be stopped when he was a absentee landowner? It had not been, that line had not been pointed out to him at the time of the conveyance. And this issue came up only later when the fence viewers were called out.
Counsel, can you, other than one's in the code, and one has a look-back period of 10 years versus, you know, any other number of time period, can you identify the differences between a boundary by acquiescence and estoppel by acquiescence?
No, I don't believe so. I mean, I'm not aware of the estoppel by acquiescence line of cases or law with regards to that. I think that's built in to the boundary by acquiescence because that is based on if two landowners acquiesce to use something else as their boundary line, even by silence, you know, by failure to act, bringing up estoppel.
Is if there's no difference, wouldn't it stand to reason that by arguing at trial, at least by arguing and presenting evidence of boundary by acquiescence, that one in fact does present and argue evidence for estoppel by acquiescence if there's no distinctions between the two theories?
That's assuming that the estoppel by acquiescence exists separate and apart from boundary by acquiescence. I'm not aware of any case law that provides that, and certainly none have been cited in this record. Your Honors, I also would request, or my client requests, that the court's order that the estoppel by deed count does not apply to a claim of boundary by acquiescence, that be reversed. And here you have the Wests who had previously conveyed this property to a predecessor and promised that they owned it, that they were conveying it, and I'll defend not only your title, but the title of anybody else down the road. They had made that conveyance, and now they're seeking to gain title to property that they conveyed and promised that they own and would defend.
It's in boundary line acquiescence.
No, it's not. In all the cases,
Every time there's to my knowledge, or at least every example I can think of, when there's a boundary line acquiescence claim, you've got adjoining parcels, and you can what the deed says, which is different than where the boundary line is that was acquiesced in, and the practical result of that is the boundary doesn't go by the deed, it goes by where the boundary that the parties acquiesced in was. So every time that happens, somebody's getting more than the deed provided for. So
In this case, Your Honor, you have the plaintiff who executed a deed and made warranties that they owned it and that they would defend the title to it. In those other cases cited by the district court, you do not have that. It's usually subsequent landowners making these claims. And pursuant to the ruling of the district court, don't warranties in deeds mean anything? I mean, the estoppel by deed argument binds the estate and any after acquired title that that predecessor may gain. And that after acquired title inures to the benefit of the successors. Well, isn't that what we have here? A boundary by acquiescence. He's claiming title to a different line than what was in his deed after the conveyance, and that is an after acquired interest. And that pursuant to the estoppel by deed inures directly to the benefit of Stajcar, and he's bound by the warranties in his deed.
thank you. You're out of time, but you'll have up to 5 minutes in rebuttal. Thank you. And Mr. Goldsmith, whenever you're ready, you can begin.
May it please the court. I'm Bryan Goldsmith. I represent Mike and Sharon West in this case. As the court has identified, we are here today arguing that the doctrine of practical location does in fact affirm the district court's finding of
That Sundance case come out, huh?
Sundance case in the middle of this case.
Do you agree that in light of Sundance, your boundary line acquiescence claim is dead, so all you're left with is your alternative claims of estoppel by acquiescence and practical location?
Yeah, the Chapter 650 claim is eliminated by the Sundance ruling. We don't argue that there was a 10-year time period. That's evident and obvious by the deeds and the facts. But the
Curious how, so basically what we're getting, the road we're going down here is an alternative ground to affirm, right? In order to get an alternative ground to affirm, you have to have raised the issue to the district court and to us, and you've obviously raised it to us, but I'm questioning how you raised it to the district court, because I'm looking in your reply to the counterclaim, you mention estoppel by acquiescence as an affirmative defense, but you don't mention practical location. More importantly, I think, in your post-trial brief, you simply incorporate by reference the briefing that you did in resistance to Mr. Steitzer's motion for summary judgment. So I did a search of your brief in resistance to the motion for summary judgment, and neither the word estoppel nor the phrase practical location appear anywhere in your brief, and I don't see that it's mentioned anywhere in the transcript anywhere either. So I'm just curious, it doesn't appear that you raised or argued that doctrine to the district court, and not surprisingly, the district court didn't address it. And so my question is, when and how do you claim that you raised those doctrines down below?
So I think it's very clear that estoppel by acquiescence was raised in the pleadings as an affirmative defense. Estoppel by acquiescence and the doctrine of practical location, I don't want to say they're the same thing, but they're virtually the same thing, right? The doctrine of practical location is essentially that when you purchase the property, if you come to the property and there is a defined boundary line that you acknowledge and recognize, and I think the evidence is very clear that that's what occurred here.
Boundary line acquiescence claim under Chapter 650, right?
They're very similar, I agree.
So we have a statute that says, by these same actions of basically just silently going along with the boundary line and accepting it as the boundary line, and if you do that for 10 years, that's the new boundary regardless of what the deed says. How can you come in when we have a statute that says 10 years and go, well, I know the statute says 10 years, but a few years is good, some other time is good enough. I mean, that seems to be nonsensical to me, that we have a statute based on this, basically a estoppel argument that creates a 10-year period, and now all of a sudden it's not 10 years, it's whatever we feel like saying is enough's enough.
Sundance and Shawland acknowledge that there's no 10-year period, and that, I mean, I don't want to say it occurs immediately, but there's no 10-year look back for the doctrine of practical location. In other words, the way that I view it is the doctrine of practical location says once it's acknowledged, then it's, when they come to the property, when they purchase the property and acknowledge that as the boundary, then that becomes the boundary and there's no 10-year requirement.
If that's the case, then every boundary line acquiescence claim should just include that claim, and then the 10 years really is insignificant. Because the facts you just described are basically, in my view, the facts in every boundary line acquiescence case.
But there can be two different scenarios. Think, for example, there are two landowners that own their land for 30 years, and 10 years between their common ownership of the land, they put up a new fence, and that new fence may not be exactly on the boundary line, or may not be, you know, where the old fence was, but they put up a fence and it's there and it's present for 10 years, then Chapter 650 would come into play there. The difference is the doctrine of practical location applies when somebody purchases the property and comes to the property. In other words, they buy the property and they accept the property as is where the boundaries are. The doctrine of practical location says that is the boundaries. Chapter 650.
That I've seen any of the scenarios of the first one that you mentioned, where you have, you know, two adjoining landowners that continue to own the land, and one of them puts up a fence and they miss the mark on where the boundary line is, and then they sit on it for 10 years. I guess I haven't seen that I can think of a case where that's the case. It's almost always where somebody comes in and purchases a parcel, and then we get into this kerfuffle, right?
I mean, I'm coming up with a hypothetical. I don't necessarily have any citations that say, here's that example, but they are two distinct and different claims and theories, in that Chapter 650 requires a 10-year look back or a 10-year time period. The doctrine of practical location does not. The doctrine of practical location, to me, is you've accepted what you have purchased and you have recognized that this is what you have purchased.
Okay, so let's go down that road a little bit. I'm a good faith purchaser of a piece of property. I look at the property with a realtor. I say, yep, looks good to me. There's a fence there. I don't get a survey before I actually purchase the property. I purchase the property, close, and for whatever reason, I get a survey and realize, oh, there's a discrepancy. And let's say that survey occurs a month afterwards. You're saying, hey, you closed on the property, you bought it knowing the fence was there, practical location, finders keepers, and you know, it is what it is. That's what I hear you saying. Am I right in that?
I think that it's a factual question as to at what point do you acknowledge and accept the fence line to be used.
You said when you come to the property to purchase it, which then leads me to my next point. Everybody's going to be getting surveys before they close on every property because they want to know exactly where it's at. And let's go down that road. Okay, so there's a discrepancy between the legal description, say, and the fence line prior to you purchasing the property. What's the good faith purchaser to do about that? Demand the neighbor to the property they don't own to tear down a fence?
Well, that's a good point and a good question. I think the reality is, in the facts of this case, we had a time period of greater than 4 years before this issue came to light.
You're telling me it's at the time you purchased the property.
I mean, that's the way that I read the law to say it. I believe that it says if you come to the property and accept the boundaries as they are, then you've accepted the boundaries, and that's the doctrine of practical location. I think in every case, of course, there's a factual determination to be made by the district court as to whether or not the boundary was in fact accepted at the time of purchase. In this specific case, we had a time period of 4 years. We had a fence viewer's finding that said this is the line and you put up this fence and here we go. And I think 4 years passing certainly acknowledges acceptance, along with the testimony in the record by the Stajcars that they saw the fence, they acknowledged the fence, they treated the fence as the boundary, they worked up to their side of the fence, and West worked up to their side of the fence.
Practical location, isn't there still a requirement that the individual knows of the discrepancy between the two?
I think that the individual has to know that the fence demarks the boundary, and I think that in that case it did.
No. Isn't there a requirement that the knowledge be that the true boundary is different than the fence?
I think, let me back up for 1 second. The reality is, and as was talked about here, when you buy a parcel and you come to it and the fences are there, the deed and the fence lines maybe perhaps don't exactly align, right? I'm guessing that virtually every fence in Iowa is not 100% on the boundary line. In this case, Stajcar's testimony was a little varied in that as far as what he thought was and was not his boundary after some cross-examination, but he certainly acknowledges that the fence was there to demark the boundary. Whether or not there's a requirement that he thinks or knows that he owns 18 feet to the other side of the fence, I don't necessarily think that to be the case so much as he acknowledged the fence, where it was at, and what the property was.
Question with regard to the argument that counsel made with regard to estoppel by deed. Can you just respond to that?
Certainly. Again, as was cited by the district court and talked about here, I mean, estoppel by deed would effectively eliminate every boundary dispute that there ever is.
To counsel's point, this isn't a situation where there were two preceding landowners other than these folks. These Wes owned all of it and then deeded to Mr. Stajcar a portion that they're now saying, no, that's mine still.
And to step back, it's not that they're challenging necessarily the title or Stajcar's ownership to that land. It's the boundary between the two properties and what demarked the boundary or what was the boundary between the two properties at the time. And so I think there's a difference there between are we challenging his title versus are we challenging what the boundary line is between the two properties, if that makes sense.
Sort of assumes that the West didn't know what they were selling.
I think they knew what they were selling, and they were selling everything to the west of the fence, which is what was accepted by the Stajcars.
The deed didn't say everything to the west of the fence. The deed said a whole lot of other things that they might not have looked at and determined exactly what it was saying.
I'm out of time. Yeah. I mean, the deed provided the legal description, and that's what it provided.
Grothe, you've got 5 minutes of rebuttal if you'd like.
Your Honors, I'd just like to make a couple comments. First of all, to Judge Sandy's point, I think there is a requirement that at the time of the conveyance, the person know that there's a difference between the actual line and the purported line. If you didn't have that, this practical location theory would swallow any type of boundary by acquiescence claim. You were there, you saw it, there's a fence, you're bound. I think Iowa law requires more than that. And then with regards to the estoppel by deed argument, I just want to make a couple points. Michael West was the one who voluntarily decided to subdivide his own property by subdividing this parcel A off. He already owned the east 5 acres, and he cut this parcel A out. And for the life of me, I don't know why. He hired the surveyor, and the surveyor didn't connect the two pieces of property, but they didn't. And then Mr. West executed the deed, which conveyed and promised, this is what I own, I'm conveying it, and I'll defend your title. That has to mean something in the state of Iowa. And this case is usually in a boundary by acquiescence case. I've had a lot of these cases. Usually you have a trial on the boundary by acquiescence claim. If the other party's successful, the second lawsuit you have is from the person who owned or who was deprived of the real estate in the deed against their predecessor in title under the warranties on the deed that they got. So why should Mr. Stajcar be different in this case, just because Mr. West was his neighbor, because Mr. West was the plaintiff, you know? He still has that right to seek redress from his predecessor for not getting what he bargained for and what was conveyed to him and what was promised that he would get.
You're making is typically in a boundary line dispute, there was no commonality of ownership, right? We got parcel 1, we got parcel 2. The buyer of parcel 2 turns out that they're missing 17.9 feet of it because the fence line has been there for more than 10 years. So their suit is against the adjoining landowner who never made any promises to them. Right. Okay.
And then if they lose on that case and are deprived of that 17.9 feet, then they go back against their grantee in their deed and say, hey, look, you promised that you own this. And I don't think that situation should be different than this situation.
Thank you.
Thank you very much.
Well, thank you, counsel, for both sides for your efforts in your briefing and your arguments here today. We will consider this matter submitted and have a ruling out as soon as we're able. That concludes our arguments for this session. We will stand in recess until reconvened with a different panel later today. Thank you.